The Affordable Care Act is at the center of House Speaker John Boehner's proposed lawsuit against President Obama, but there is a lot more to this potential looming court battle. According to many legal scholars, it's about the balance of power.
There's a growing crisis in our system, a shifting of the balance of power within the tripartite system in favor of a now dominant chief executive. While both Congress and the courts have lost authority over the decades, it is this body, the Congress, that has lost the most in this rise of a type of Uber presidency.
Well, Rich Lowry is the editor of National Review and a Fox News contributor. Thank you for joining us.
My pleasure.
So just in the past couple of days, you've had two highly respected legal scholars coming out and saying, we do support this lawsuit against the Obama administration. They are overstepping their bounds. One of them is Turley, who we just heard from, describes himself as a liberal, but very concerned about this potential overstepping. Let's hear more of what he has to say.
The president's pledge to effectively govern alone is alarming. And what is most alarming is his ability to fulfill that pledge. When a president can govern alone, he can become a government unto himself, which is precisely the danger the framers sought to avoid.
All right. He goes on to say that this Uber presidency, as he calls it, is dangerous. It is destabilizing the country. What do you say about all that?
Yeah, I think all that's right. This is a serious deformation of our constitutional process. And if you look at the employer mandate instance, which is what the House is going to sue over, you get the employer mandate written black and white in the Obamacare law. It's going to start 2014. And you have the administration delaying it twice and actually writing new provisions and new requirements on employers. That's just not how the process is supposed to work. So what Speaker Boehner is trying to do is go to the courts and repair what he thinks is an institutional injury that's been done to the House, because it's supposed to write the laws.
Yeah. And there's another scholar also coming out, Elizabeth Foley, a professor at Florida University College of Law. She says that this has an excellent chance of succeeding. Not all lawyers agree with that aspect. Yeah. There is the question of standing. Explain that.
Right. So she is one of the architects of this lawsuit, together with a lawyer named David Rivkin in Washington. And the question of standing, I guess, real technical, but as a limit on the power of the courts, the Constitution and jurisprudence say you have to suffer some real, discernible, specific injury that has to do with some unlawful action for you to bring suit and to be heard in the courts. So the question here is whether the House has suffered such a specific, discernible injury. And we're really going to go in uncharted territory here, because it will be a novel finding if the courts say the House in and of itself has suffered an institutional injury such as that it has standing and can pursue this in the courts.
Right, and also it's so time-consuming that Obama will be long out of office before any of this is resolved. But in the meantime, because of that, critics of this proposed lawsuit say, look, the Congress has other avenues that it can pursue to address this issue. Why not go a different route?
Yeah, well, the Congress has powers it can wield against an out-of-control executive. The power of the purse, it can defund certain agencies, impeachment, kind of the nuclear option. But the House is looking at those and saying, well, we don't control the Senate, so we're not going to go anywhere with those, so let's try this instead. And I think the fact that this will have very little practical effect on the law really speaks in favor of the lawsuit and goes to the point they're trying the House to vindicate a principle, which is that the legislature writes the laws and the executive is supposed to faithfully execute them.
Right. And, you know, the principle, as we mentioned, goes beyond the specific grievance, which is the Obamacare employer mandate, and goes to just other areas of overreach, and you've written about several of them. What would you say are the most egregious examples of overreach?
Well, there are a number of them in Obamacare, and then I would say immigration law is a huge one and has colored the entire debate over immigration in Washington. So-called comprehensive immigration reform, one of the reasons it couldn't get through the House is as House Republicans say, well, look, he's effectively waived a bunch of immigration laws. Why would we trust him to enforce the new law we're going to write? And you see that even playing into the debate over the current border crisis, where a lot of Republicans are saying, we're not going to give you more money or more authority if you're going out and telling immigrant groups that you're going to waive even more laws come the fall. So this is an enormous part of the debate in Washington.
Yeah. All right. We'll see where it goes. Rich Lowry, National Review. Thanks as always.
Thank you very much.